Hello, everyone. This is Tom Fox back for another episode, and I'm absolutely thrilled today to have back my good friend and colleague, Alexander Cotoia. Alexander, first of all, welcome back.
Time's been a while, glad to be back.
Yeah, it's been way too long, but we're going to remedy that today because we're going to talk about one of the lesser known areas of compliance and even further down trade compliance that you blogged about. And the area is anti-boycott law. And let me just get the title of your blog. We, of course, are going to link to it in the show notes, but you posted a blog on corruption, crime, and compliance. BIS reaches $151,000 settlement with Quantum Corporation over violations of the EAR boycott provision. So maybe, Alexander, you could start by explaining to our audience what is EAR's boycott provisions.
Absolutely. Thank you for having me again, Tom. And I think it's a really important topic because anti-boycott compliance is a subject that's not only intricate, but also profoundly impactful, especially for U.S. companies that conduct business globally. And these laws address some of the fundamental values that underpin U.S. foreign policy. And they emphasize a unique blend of regulatory principles that aim to maintain the U.S.'s stance in neutrality over conflicts. But to your question, anti-boycott law is companies from participating in or supporting foreign imposed boycotts that are not endorsed by the U.S. government. So,
Alexander,
yeah,
I'm getting a lot of feedback from your mic. Do you have a set of headphones or earbuds you could put in?
no, I don't, Tom. Hold on one second. Hold on one second.
I'm going to just play some music and double check and just make sure it's not my headphones.
Now, my daughter took my headphones today, which is probably not the opportune time to do that.
Nope, it's not my headphones.
All right, let me see if I can dig up here. Hold on one second.
All right.
And no success with those. I'm using a microphone externally. Do you think if I should wear it?
Let's try that.
Adherence. All right, can you hear me now?
Yep, with no feedback.
Wow, there we go. All right. So it's the external microphone then.
Yeah. Okay. We'll need to start over, but that's not a problem.
Sorry about that.
Okay, I'm going to take a 5-second silent count so I know where to edit, and we'll go from there. So, hello, everyone. This is Tom Fox back for another episode. I'm absolutely thrilled today to have back with me my good friend and colleague, Alexander Cotoia. Alexander, first of all, welcome back. It's been way too long.
Thanks, Tom. Glad to be here and joining you on the podcast again.
Alexander, I think in September, you wrote a very interesting blog post, actually early October, entitled BIS Reaches $151,000 Settlement with Quantum Corporation over violations of the EAR's anti-boycott provision. You posted that on the site Corruption, Crime, and Compliance, and we're, of course, going to link to it in the show notes. And that was really the genesis of me reaching out to you because although as a lawyer from the energy space, I certainly know what the boycott provisions are. My sense is many lawyers don't know what they are, and they could get in significant trouble really without even knowing it. So, with that, first of all, incredibly long-winded introduction, welcome back to the podcast.
Thanks, Tom. I'm really glad to be joining you. And I think you're right. I think this is an area where a lot of people outside of trade compliance or outside of certain fields really don't have a firm grasp on what these regulations mean.
Alexander, could you start off by maybe giving us some highlights of what is the EAR's anti-boycott provisions?
Absolutely. Tom, the anti-boycott provisions in the Export Administration regulations, it's a framework that generally prohibits U.S. companies from participating in or supporting foreign imposed boycotts that are not otherwise endorsed by the U.S. government. Now, the law emerged in response to the Arab League boycott of Israel in the 1970s, I believe, which put pressure on American companies to align with foreign policies that conflicted with U.S. principles of free trade and equal access. So these laws are codified in the Export Administration Act and the Internal Revenue Code, and they include several prohibitions. Specifically, U.S. companies cannot engage in activities that support unsanctioned boycotts, such as agreeing to refuse to conduct business with blacklisted entities, providing information about a company's relationship with boycotted nations, or entering into contracts with language that aligns with foreign boycott activity. Now, the law generally mandates that U.S. companies adopt a neutral stance when they face foreign led boycott pressures. And I think what's so unique about the anti boycott laws is the focus on active reporting. Companies are not only prohibited from participating in foreign boycotts, but they're also required to report any requests that they receive to comply with such boycotts to BIS, the Bureau of Industry Security at the Department of Commerce. And the reporting mandate allows BIS to essentially track the extent and nature of foreign pressures on U.S. companies, especially pressures that may impact U.S. foreign policy interests. So the law serves a crucial mechanism to ensure that American companies aren't inadvertently used as instruments of foreign policy in ways that could undermine U.S. trade or political alliances.
Alexander, who enforces the anti-boycott provisions, and is that enforcement different than other trade sanctions or export control sanction cases?
Yeah, so the enforcement of anti-boycott laws in the U.S. is primarily handled by it's bifurcated. It's handled by two agencies: the Bureau of Industry and Security under the Department of Commerce and the Internal Revenue Service is also involved. This is primarily responsible for monitoring companies' adherence to the anti-boycott provisions as they relate to trade. And BIS's focus is on the impact of boycotts on U.S. exports, re-exports, and related technology transfers. And their goal is essentially to ensure that U.S. firms operating internationally don't engage in discriminatory trade practices that otherwise conflict with U.S. principles. So, by maintaining oversight in that area, BIS helps to protect American businesses from being pressured into complying with practices that could undermine U.S. trade relationships. Now, on the other hand, the IRS enforces anti boycott laws from a tax perspective, specifically concerning the tax code provisions that relate to participation in foreign boycotts. Now, the IRS has the authority to deny certain tax benefits to companies that engage in or fail to report boycott activities. And the rationale for the dual enforcement approach is to provide a comprehensive compliance framework that addresses both the trade and financial dimensions of anti boycott obligations. Essentially, BIS ensures that companies don't take actions that align with foreign boycotts, and the IRS creates financial disincentives for those that might be tempted to do so.
Alexander, let's turn specifically to quantum. How did quantum violate the anti-boycott provisions?
Yeah, so it's a very intriguing case. In Quantum's case, the company encountered boycott related language in its dealings with business partners that were situated in the United Arab Emirates, the UAE, a region where boycott pressures are more prevalent. Those requests involve stipulations in contracts or communications that require Quantum to comply with UAE based boycott policies against the State of Israel. Under U.S. law, Quantum was required to report those requests to the Bureau of Industry and Security, even if they chose not to comply with those boycott demands. But Quantum's oversight was that it failed to report those requests. And I think they amounted to about 45 separate instances of failing to report those requests. And that led to BIS imposing a rather sizable monetary penalty on them, over $151,000. I think what's critical about that violation, Tom, is that it wasn't necessarily about quantum taking action to comply with the foreign boycott. The penalty was due to the omission that they created in not reporting those requests in first place. This places a high premium on reporting because it allows that agency to track and respond to foreign boycott pressures on U.S. companies. And when companies fail to report, they hinder the INS's ability to monitor those pressures and otherwise protect U.S. business interests abroad. So the quantum case to me underscores that anti-boycott compliance isn't just about actively refraining from engaging in boycotts, but also about promoting transparency and adhering to those reporting obligations.
Alexander, as I started off at least in anti-bribery, anti-corruption compliance, have some anti-money laundering compliance, and occasionally dabble in your expertise of trade control and trade sanctions and export control. But this failure to report is really unique across compliance, I think. Is that correct?
It really is. So the failure to report aspect of anti-boycott law is unique because it mandates kind of a proactive stance with respect to trade compliance. So unlike many regulatory frameworks where violations occur primarily from taking the prohibited action, the anti-boycott laws penalize companies for merely failing to disclose certain information. So the requirement's significant because I think it reflects BIS's overall commitment to keeping the U.S. government informed about the nature and extent of foreign boycott pressures. And by kind of requiring reports of all boycott related requests, BIS can monitor the reach and intensity of those pressures and really begin to assess how they might impact U.S. interests and business practices.
Why is there such a strict not why is there such? There is a strict liability nature to this law. Why do you think that's in place, and how should compliance professionals be aware of this?
Yeah, it's crucial. I think it means because it means that companies can be held liable regardless of their intent or awareness. So strict liability in this context, in the anti-boycott dimension, places the burden of compliance squarely on the company, emphasizing that even an unintentional failure to report a boycott request or an inadvertent agreement to comply with a foreign boycott can result in significant penalties. And that approach underscores that anti-boycott compliance isn't just a matter of following the law when it's convenient, but that it requires an ongoing commitment to neutrality in international dealings. And I think in practical terms, that means that companies need to implement stringent internal controls and regular training across all departments that might encounter a boycott related language, such as sales, legal, and compliance teams. These employees need to understand not only the basics of boycott compliance, but the critical importance of reporting any suspicious or potentially boycott related requests. And given the strict liability standard, even small oversights like missing a single clause in the contract or purchase order or overlooking an offhand request from a foreign client can have serious consequences.
Alexander, does that mean if representing a client, receive a contract which has that request, I can't negotiate it away? I have to report it before I attempt to negotiate it away?
And it does place that burden on you. If you receive a request to participate in the foreign boycott, regardless of what form it comes in, then you have an obligation to report that to the IS. You can attempt to negotiate it away, which many companies are um, attempting to do, but you do have an obligation to report that you even received it.
I'm not aware of really too many enforcement actions in this area. Is my awareness simply incorrect, or is it a relative paucity of enforcement actions in anti-boycott clauses?
Yeah, no, you're right, Tom. I think enforcement actions and anti-boycott compliance are indeed relatively infrequent. I think there are a couple of reasons for that. First, I think U.S. companies with strong international presence have generally become quite adept in identifying and handling boycott-related language, as we talked about before we came on. And so they are often used to incorporating the anti-boycott compliance into broader export controls and international trade compliance frameworks. And that awareness and training have reduced the overall number of violations, I think. Um, Second, anti-boycott requests are often concentrated in specific regions, particularly in the Middle East, where companies have a greater likelihood of encountering those types of pressures. So many companies that operate in those areas already have robust compliance systems in place. So they're well prepared to handle boycott requests without violating the law. And finally, I think the relatively low number of enforcement actions might also be a testament to the effectiveness of the reporting requirement itself. By mandating reporting, BIS has created a self-monitoring mechanism that allows companies to disclose potential issues proactively. And so when enforcement actions do occur, they often highlight gaps in compliance programs or insufficient employee training, as seen in the quantum case.
What I think you've answered this, but I want to specifically give a question. So if our listeners didn't get it, you give the answer, which are what are the best practices in this area from your perspective, Alexander?
Yeah, and best practices for anti-boycott compliance really start with comprehensive training, especially for employees who might interact with foreign partners or work on international contracts. I think those employees need to recognize that the kinds of language that could constitute a boycott request, such as terms requiring the exclusion of certain nationalities or stipulations against working with certain countries. And I think the training should also cover the reporting obligations and emphasize that failing to report can be just as serious as actively participating in the boycott. And from there, I think automated tools can play a helpful role in identifying potentially problematic language in contracts, purchase orders, or other communications. I know that many companies are using keyword flagging systems that can alert compliance teams to phrases like Israeli or boycott, thus ensuring that those issues are reviewed promptly. And like anything else, regular audits and compliance reviews are also essential. They provide an opportunity to ensure that all departments understand and adhere to anti boycott obligations and that any potential violations are caught early. I think key here is also establishing a clear internal escalation process that allows employees to report the receipt of boycott related requests to the compliance or legal team for assessment, ensuring prompt action and minimizing the risk of noncompliance.
Alexander, one of the things that has intrigued me about this law since I became aware of it was that it's not just Arab Israeli. It's not just limited to the Middle East. There are actually other areas that this law covers. I was wondering if you might highlight those. And then I'm going to specifically call out China and Taiwan because I think that's going to be the next big area of potential anti boycott concern. Now that I've given that away, what are the other areas?
Yeah, so the Arab League boycott of Israel was the impetus of anti-boycott regulations, and but the laws apply broadly to any foreign-led boycotts of any kind. So that means that companies need to be vigilant when conducting business with partners or regions where boycotts are prevalent, even if they aren't related to the Middle East. So, for instance, certain regions may have boycotts based on religious, political, or economic grounds. Countries like Pakistan or Bangladesh, for example, may enforce boycotts for reasons tied to regional disputes or political alignments. And the law's broad applicability emphasizes that companies must exercise caution whenever a foreign entity requests exclusionary practices or boycott compliance, regardless of where that pressure originates.
So let's turn to China, Taiwan, because this is the area that really interests me the most. I can certainly see the Chinese mainland, the Chinese national government, the Communist Party of China start to exert pressure in their contracting with Western companies. And I hope Alexander Cotoia and the Volkov law firm are sounding that clarion call that people need to be aware. And these were for industries that may not have typically had to face these issues as widely as pharmaceutical, obviously chip or technology companies, even movie industries. So I want to maybe get your thoughts on how can we get this word out about China and Taiwan? Or conversely, do you see, Tom, that's really not going to happen, or I don't think we need to worry about it perhaps as much as you do?
No, I think you're right, Tom. I think this is going to be an area where we need to more closely monitor China's activity with respect to Taiwan, especially because I think the geopolitical situation generally is kind of degrading or destabilizing over time. I think China is going to become more bold. And the reason they'll become more bold is the fact that they're going to follow, I think that they're going to take a page on the Russian Federation's playbook and become a little bit bolder in their play for Taiwan. So, given those tensions between China and Taiwan, U.S. companies need to proceed with caution. Although, obviously, the anti boycott laws don't specifically address that particular geopolitical issue, the underlying principle of neutrality and non participation in foreign directed economic discrimination is relevant. So, to navigate that situation, companies need to adopt what I might call a watchful neutrality approach. And that means avoiding actions that could be construed as taking sides, such as agreeing to requests that single out one party to the dispute. And given that potential for escalation, I think companies should regularly review their compliance protocols, or remain up to date with BIS and State Department advisories. Many companies are choosing to incorporate additional monitoring for business in China and Taiwan already to ensure neutrality, so that they should continue to do that. And lastly, companies should work closely with compliance and legal experts to prepare for any shifts in regulatory guidance related to U.S. China Taiwan relations to ensure that their operations remain aligned with both existing and potential future requirements.
Alexander, you win an extra gold star if you announce the name of the podcast in your remarks. Watchful neutrality. Absolutely brilliant. I'm going to purloin that phrase from you, and I hope you write a blog post on that because I think that's something that'd be a great way to think through this. Unfortunately, we are near the end of our time for this episode, but before we leave, Alexander, I wanted to ask you if our listeners wanted any more information on yourself, perhaps link with you or connect with you, what might be the best place or places for them to go?
Absolutely. They can visit our website, which is www.volkofflaw.com, or they can contact me directly by email, and that's Cotoia, ACOTOIA, at volkofflaw.com.
Alexander, always a pleasure to visit with you. I promise not to wait as long next time. And in the interim, keep cranking out those great blog posts.
I appreciate it, Tom. Thanks. Glad to be with you.